Hello guys, and welcome back to another episode of my lecture. In my last class, I spoke about removal of directors, and I even cited and explained the case of Iwuchukwu versus Nwenzu. So, the first provision we need to start with is section 88B. Section 88B says, unless otherwise provided in this act or in the Articles of Association, the Board of Directors may from time to time appoint one or more of its members to the office of Managing Director and may delegate all or any of its powers to such director. Note that this provision is a default provision, which means if you don't want the Board of Directors to appoint the Managing Director, stipulate it in your articles that you want to give the power to the members in general meeting, or you want to give the powers to a third party. Do you understand? Stipulate it in your articles. But where you don't stipulate it in your articles, the mandatory provision in this default provision is that the Board of Directors must choose amongst its members. Do you understand? To appoint a managing director who they can delegate some of its powers to, or who they can delegate all its powers to. Now, the Board of Directors may appoint one or more from their body to the office of the Managing Director and may delegate all or any of their power to such Managing Director. So, in the absence of the contrary provision in the Articles or in the Act, Managing Director comes from the Board of Directors. That means that he must first be a director before he can be a Managing Director. Note that the power to hire also carries along with it the power to fire. When you look at the provision of 88B, it says that they have the power to appoint any of its members. While you are reading 88B, you must read it in line with section 11 of the Interpretation Act. The person who can appoint you can also fire you. So if the board can appoint the managing director, then the board, by virtue of section 11 of the Interpretation Act, can also fire you. So now, the managing director is the chief executive officer. Remember that every director operates in two capacities. The first one is the staff, that's an employee before he is a director. So a director can only be removed by the shareholders in general meeting. If you remove a managing director, it does not automatically mean that you have removed him as a director, because there is a different procedure entirely for removal of directors, and that can be found in 288. If you want to remove a managing director, you go under 88B. So most times when there is a person to be appointed as the managing director, there is usually a contract between the board that's representing the company and the managing director as to how many years he will stay, what are the implied conditions for this particular contract, what are the things you can do, the things you cannot do. So it's either in a separate contract or it has been enshrined in their articles. Do you understand? So continuing with the note, he said that in this context, the MD can be seen as the executive officer appointed by the board and removable by the board, and a director who is a servant of a company can be removed by the company in the general meeting. This means that the Board of Directors can only terminate the managing director by virtue of section 88B and section 11 of the Interpretation Act, but not his office as director, because this power belongs to members in general meeting pursuant to section 288 of Cama 2020. This removal by different organs obviously look clumsy. Most companies often misunderstand this distinction, and then they go on to remove the managing director in his capacity as both managing director and director from the board, instead of by ordinary resolution. Do you understand? Because they say, oh, the power to hire comes with the power to fire, which means that when you are interpreting 88, we can remove him as the managing director and remove him as the director. That's the lie. If you are removing him as the managing director, that's fine. You have the power to hire, you have the power to fire. However, if there is a contract that says that he's going to be a managing director for 3 years, and then you remove him before the expiration of 3 years, then he can collect compensation. Do you understand? But in the absence of such contract, though, it then means that there will be no compensation, as we can see in the case of Iwuchukwu versus Nwenzu, where the court said that there has to be an express service contract. Do you understand? So then, to make matters worse, they even failed to give managing directors notice of the meeting where they are about to remove him, which is contrary to the provisions of the law. So now we are going to look at the case of Bernard Ojeifo Longe versus First Bank Nigeria PLC. In this case, we are going to see how they suspended the managing director of First Bank and later removed the managing director of First Bank. And we are going to look at, was the procedure done in accordance with the law? Do not forget that in Iwuchukwu versus Umuizu, the procedure was not done in accordance with the law, because if you are to remove a director, you have to follow the provisions of 288 subsection 1. They said that they are giving him notice according to his contract as a special assistant. The court held that no, is when you want to terminate his appointment as special assistant to the managing director that you give him such notice. But when you want to terminate his appointment as a director of the board, you must follow 288. So let us see what the court held and the fact of the case. Very interesting one in the case of Bernard Ojeifo Longe versus First Bank Nigeria. I will see you in my next class.